Council here at Massachusetts Office on Disability. And you're here today for our Municipal ADA Coordinator Basics training. So the goal of this training is to provide a foundation for municipal ADA coordinators to do their job. So this is going to be a pretty basic training. We're going to cover both Title I and Title II of the ADA in this training. And before we get started, I want to give a quick overview of what the Massachusetts Office on Disability is and the services we offer. Massachusetts Office on Disability is a statewide government agency that works to ensure that people with disabilities can equally participate in all aspects of life in Massachusetts. And to do that, we provide information, guidance, and training on disability-related civil rights and obligations, including those related to architectural and programmatic accessibilities. And we work really closely with state agency ADA coordinators and municipal ADA coordinators to, do their jobs, to do a good job at serving both public employees and members of the public who are seeking services from state and local entities. So we're here to be a partner and a resource to you as municipal ADA coordinators. And today's training is to really build that foundation. As we enter the new year, we're planning on doing a lot more programming for municipal ADA coordinators. At the end of this training, you'll get a survey that will ask you if you want to participate in a municipal ADA coordinator group that we're putting together, where we're hoping to facilitate more training, more dialogue between municipal ADA coordinators to provide you more support in serving your constituencies. So if you're interested, be sure to register your interest in that survey after this training is concluded. So today, we're going to go over an overview of disability laws. We're going to talk about the definition of disability under the Americans with Disabilities Act. And then we're going to talk about two titles of the Americans with Disabilities Act. First, Title I, employment. So the work that you'll be doing as an ADA coordinator that's internally facing for the employees of your municipality. And then second, we'll talk about Title II, which is the external work that you'll be doing, which is how you will be interacting with members of the public who are going to ask for reasonable accommodations in order to access your your local government services. At the end of both of these sections, we're going to do a couple interactive scenarios. So I will invite people to raise their hands. I'll pick one or two people, and you can, try to participate in those interactive scenarios, and hopefully that will be fun. At the very end, we're going to go over some resources, my favorite resources for ADA coordinators. You should have received a copy of this slide deck yesterday. If you haven't gotten it because you registered after it went out, don't worry. Another copy will be going to you again after this training today. And on that last page, we have a number of links to the resources that I recommend. So, it's really helpful to keep that page in your back pocket as you're going about your daily work. So I'm going to start with an overview of federal disability laws. First, I'd like to talk about Section 504 of the Rehabilitation Act, 1973. This was the first federal legislation that sort of guaranteed non-discrimination and civil rights for people with disabilities, but only in the context of federal programs or programs receiving federal funding. So under Section 504, federal programs and programs receiving federal funding are prohibited from discriminating against people with disabilities, and they're required to provide reasonable accommodations, which is a concept we're going to talk about a lot today, to people with disabilities in order to allow them to access those programs. We'll go into more detail on reasonable accommodations later in the training, but keep it in your head because it's going to live there forever. So this applies to to federal programs and federally funded programs. So if your town has any federal grants, the program that's funded by that federal grant is going to be covered by Section 504. So it's something important to be aware of. Now, almost 20 years after the ADA was passed, Congress passed the Americans with Disabilities Act, which takes that non-discrimination requirement and the requirement to provide reasonable accommodations from Section 504 and applies it to more types of entities. So it applies to employers under Title I of the ADA. It applies to state and local governments under Title II. It applies to places of public accommodation, which are businesses that hold themselves open to the public under Title III, and also telecommunications, Title IV, some other miscellaneous provisions as well. It's very similar to Section 504 in its prohibition against discrimination and its requirement to reasonably accommodate. We'll go into more detail about both Title I and Title II today. We're not going to talk about Title III because it's a little outside of the scope of what a municipal ADA coordinator is going to do on a day-to-day basis. But if you have questions about Title III, you're always welcome to contact MOD and we'd be happy to help you out. Now, I always like to talk about the ADA Amendments Act of 2008. This is a really important piece of legislation because Congress took a look at how the courts had been interpreting the ADA over the last 20 years-ish, 18 years. And they said, you know, the courts are really interpreting this act too narrowly. And they were concerned that the way that the courts were interpreting the ADA was going against the legislative intent of the act, which was intended to, which they wanted to be interpreted broadly so that the protections afforded by the ADA were broadly provided to the greatest number of people and to the greatest amount of protection. So the ADA Amendments Act makes clear that the definition of disability and the protections afforded by the act are both intended to be interpreted broadly. Now, some lawyers forget that the ADA Amendments Act was passed. And so if your town council doesn't do a lot of work with the ADA, they might not be aware of this Amendments Act. And it's good to remind them so that when they're advising you or advising the town on issues related to the ADA, that they shouldn't really be looking at case law that's before 2008, before the act was passed, because it's probably going to be bad law. So I'd like to tell you about it because I think it's helpful if you can remind your town council, remind yourself that you know, we really have to be careful when we're doing case law research around the ADA to use fresher cases, because anything prior to 2008 could be bad law if it's, you know, taking too narrow of an interpretation either of the definition of disability or the protections afforded by the act. So keep that in mind. As I said, the ADA has 5 titles. We're going to focus on Title I, Employment, and Title II, State and Local Government Services. I like to start with the definition of disability under the ADA before we get too in depth on the provisions in Title I and Title II, because I think it's a helpful place to ground ourselves. So when we're talking about disability in the context of the ADA, and this is going to apply for state law too, the definition is very similar. We're talking about a physical or mental impairment that substantially limits one or more major life activities of an individual. That definition really has three parts. So you're going to be looking for three things. You're going to look for that physical or mental impairment. I'm going to talk about it today as a functional limitation. That's language that the ADA uses, that the DOJ uses in the regulations. So you're looking for a functional limitation that a person has that is going to substantially limit. So you're looking to make sure that impairment is substantially limiting, and it has to limit a major life activity. So a major life activity is basically an activity that is of central importance to daily life. It can also be a major bodily function. Unlike disability, which we don't have a list of, there is a list that's not an exhaustive list, but an inclusive list in the regs of different kinds of things that are major life activities or major bodily functions. So some examples of that could be working. It could be communicating. It could be walking, breathing, hearing, seeing. There's a broad range of things that are going to fall under major life activities, but a major life activity is going to be something that is pretty core to what makes us human. It's not going to be, texting. Maybe it's going to be texting. We're always texting these days, but it's not going to be sort of an ancillary activity that we do. It's going to be something that's kind of a core activity. A person is also going to be protected by the ADA from discrimination based on disability if they don't meet that actual disability definition that we just talked about. But if they used to have an impairment that no longer affects them or no longer substantially limits a major life activity. So an example of that might be someone who had cancer, who is now in remission, would be protected from discrimination on the basis of disability based on that past history of cancer. So you couldn't discriminate against someone because they used to have cancer and no longer have it. You also cannot discriminate against someone who is perceived as having a disability, even if they don't actually have a disability. So an example of that I think is helpful are people who have facial scarring. They look different, and so oftentimes they're treated differently by society, but they don't have an impairment that is substantially limiting a major life activity. There isn't that limitation, and there isn't that effect on a major life activity there. And so they're not meeting that actual disability definition, but you can't discriminate against them because you think of them as being different because they might have a disability. Now, folks that fall into those last two categories, the history of disability or the perception of disability, they are protected from discrimination, but they aren't entitled to reasonable accommodations because there's nothing to accommodate. You have to have that limitation that requires accommodation in order to trigger the obligation to accommodate. So keep that in mind when you're thinking about how you're structuring your programs. You have to make sure that your programs aren't going to inadvertently discriminate against people in these two categories. But if someone from one of those two categories asks for something, you may not have to grant that request if they don't currently have an impairment that requires accommodating. So we're going to start with Title I, employment. And the ADA prohibits employers from discriminating against qualified individuals on the basis of disability in regard to job application procedures, hiring, advancement, discharge of employees, employee compensation, job training, or other terms, conditions, and privileges of employment. This is a really broad non-discrimination mandate. It doesn't just apply to when an employee is sitting at their desk. It starts prior to that, when they're applying for jobs and throughout the job application process. It also applies to all of the benefits of employment, whether those are tangible benefits or social benefits. So it applies to employee compensation and benefits packages, but also it applies to your office holiday party. You know, pretty timely. You have to make sure that your holiday party is in an accessible location and that you're providing reasonable accommodations to employees who need help accessing that holiday party. So discrimination is going to include an adverse action against an employee because of their disability. So disciplining them or firing them or demoting them because of their disability. But it also includes excluding people with disabilities from the benefits around a job. So do they have access to the employee break room? Do they have access to the holiday party? Do they have access to the employer-sponsored softball team? You know, that is going to be part of employment if it's offered to all employees. You need to make sure that you're thinking about how to make that accessible for all your employees. It also, discrimination is going to include failure to provide reasonable accommodations to otherwise qualified employees. Now, what is a reasonable accommodation? I've been using this phrase a lot today. An accommodation is any adjustment or alteration in the workplace that enables a person with a disability to apply for jobs, to perform the essential functions of the job, or to enjoy the benefits and privileges of employment. A reasonable accommodation can take so many different forms. And honestly, that's what makes the job of an ADA coordinator really interesting, because it's an opportunity to be creative. You know, accommodations might be auxiliary or communication aids or services. So today we have an ASL interpreter, two ASL interpreters here who are providing interpretation services. We also have a CART reporter here who is providing live transcription. Those are examples of communication aids and services. It might also be equipment. Some people are going to need special equipment to do their job. Maybe they need a Braille keyboard. Maybe they need a standing desk or a talking clock. It can also be removing barriers. Maybe somebody needs a modification to their cubicle so that they can fit in it comfortably with their power wheelchair. It might also mean providing a reasonable modification to policies, practices, and procedures. And this is where you get really creative, because you know, especially in government work, we really like bright line rules. And what the ADA says about that is that you can have bright line rules for your employees, but if an employee with a disability needs an exception to that bright line rule, you need to figure out whether or not you can make an exception for them. And we're going to talk about the interactive process and how you're going to arrive at that decision. But pretty much any policy, practice, or procedure of your organization is, you know, up for modification if necessary to enable access for someone with a disability. So maybe that's allowing someone to bring their service animal to work. Maybe it's changing their work schedule. Maybe it's allowing them to telecommute. It has to be reasonable. We're going to talk about what that means later, but pretty much any rule is fair game. So I like to start with everybody's first question, which is, when can I say no? Because I've worked in public service for my whole career, and I know that, you know, when somebody asks for something, the first instinct is, how do I get out of this, right? So I'm going to answer that first so you can kind of let go of it, and then we can go into how you're going to go about making your decision. So an employer can deny a request for reasonable accommodation for one of three reasons: undue financial burden, undue administrative burden, or fundamental alteration. Now, what do those mean? Undue financial burden is a tricky one because a court is going to look at a claim of undue financial burden by an employer, and they're going to consider the municipality's entire budget for that fiscal year. So they're not just looking at the budget for the library, if it's a library employee, or the DPW, if it's a DPW employee. They're looking at the entire municipal budget for that year, which is going to be pretty big. And so in comparison, the costs associated with a reasonable accommodation it's hard to show that those are unduly financially burdensome. It's possible, but it can be really hard to demonstrate. So you have to be careful when you're using that as a reason to say no. Some accommodation requests might be unduly financially burdensome. If you need to hire a full-time equivalent, an extra full-time equivalent employee, that might not be financially feasible for your organization. So be careful when you use that one, because it can be a little tricky. Undue administrative burden is going to come up where the accommodation requested is just unworkable or is going to create a lot of extra work for other people within the organization. So you're going to see that, when you're, shifting functions from one person to another, or if somebody else is going to have to sort of do a lot of work in order to make this accommodation, come to fruition. And then the last one, fundamental alteration, you're going to see that in the employment context, you're going to see it a lot when people are asking to waive an essential job function. You are not required as an employer to waive the essential functions of a person's job as a reasonable accommodation, because that would fundamentally alter the nature of the job. You're also going to see fundamental alterations if the accommodation that's requested would sort of fundamentally change the nature of the service that your entity is providing, or would sort of fundamentally alter the structure of a building. You're going to see those less in the employment context. More you're going to see, folks trying to waive an essential function of their job, and I would call that a fundamental alteration. So you can say no for three reasons. But how are you going to get there? Or on the other hand, how are you going to get to yes? Or how are you going to get somewhere in the middle, which is probably the most common thing that you're going to do. So you're going to go through the interactive process with the person. And the interactive process is really the cornerstone of the ADA. It is the dialogue between the requester and the entity to arrive at a solution. You need to initiate this as soon as you can upon receipt of the request. So you need to reach out to the employee to discuss their needs and their functional limitations and how those functional limitations are impacting them at work. Because the purpose of the interactive process is to sort of find that match between how do a person's functional limitations interact with the essential functions of their job. Are they able to perform the essential functions of their job? If they cannot perform the essential functions of their job, even with accommodation, you might, then they're not protected by the ADA anymore. The ADA covers qualified individuals with disabilities. So you're going to need to understand what the person's functional limitations are, what the essential functions of their job are, and how you can accommodate them in order to allow them to perform the essential functions of their job. So sometimes what an employee asks for isn't something that you can implement. And that's okay, but that doesn't mean that you say no and the conversation stops. You are required to offer alternatives if you're unable to implement the reasonable accommodation as requested by the employee. So a good place to get ideas for alternatives is the person's manager, because they know the job the best. So they might be able to think of some workarounds that could help this person. Another good source, which we're going to talk about at the end, is the Job Accommodation Network. Is really good at identifying other options for accommodating someone at work. It's a really good practice to establish a reasonable time frame for responding to these requests. In the executive branch, we require our state level ADA coordinators to respond to reasonable accommodation requests from employees within 20 business days. Sometimes that's not possible. And if it's not possible to respond within 20 business days, we require our state ADA coordinators to update the requester at least once a month in writing. So I'm not saying that you have to implement that same timeline within your town, but it's a good idea to have a policy in place that gives you a time frame so that you can make sure that you are meeting that time frame. And that's going to help you, ensure that you're complying with your obligations under the ADA and internal policies around accommodations. It's also really important that you keep disability-related information confidential from other employees. So we're going to talk about medical documentation on the next slide, but for now, it's important that you know that only people who need to have information about the disability in order to do their job are allowed to have information about that reasonable accommodation request. So the fact of the request is confidential and can only be disclosed on a need to know basis. And the only information that you're going to disclose is the minimum amount of information that someone would need in order to accomplish the task that they have to do to carry out that reasonable accommodation. So an example of this would be if you're needing to procure something for an employee with a disability. You're going to provide your procurement department with the bare minimum information that they need in order to order that equipment. So they're going to need to know what the equipment is. They're probably going to need to know who the employee is who's going to receive the equipment and where their office is. But they don't need to know any other information about the employee or about the employee's job in order to put that order in. Same goes for sort of more programmatic changes. You are going to only tell people within the employee's office the bare minimum of information that they need to know in order to sort of implement that accommodation. So The employee, if you're, say changing a person's work schedule, you're going to tell the employee's supervisor that an accommodation has been approved for this employee for an alternative work schedule and what those hours are. The employee's colleagues don't need to know that information, or that it's because of a reasonable accommodation. So how I like to handle this, and what I tell, the supervisors, the managers that I work with, is their line that they can use is, Christina has been approved for a reasonable, has been approved for an alternative work schedule. I'm not going to say reasonable accommodation. She's been approved for an alternative work schedule. This has been approved by management. It's a personnel matter, so we can't discuss the details of it the same way that we wouldn't discuss your personnel information with other employees. And that's kind of the line that I use with people, and it seems to work. You're not going to say, Christina has a reasonable accommodation to come in late, because you cannot disclose that it's a reasonable accommodation or related to an employee's disability. The fact of a reasonable accommodation, the fact of an employee's disability is confidential, and only you, as the ADA coordinator can have that information. Now, medical documentation is a hot topic. And I've seen requests for medical documentation used to sort of delay, as a delay tactic, or as a way to deny reasonable accommodation requests. I'm here to warn you that that's a bad idea. You can only request medical documentation if an employee's need for the accommodation is not obvious. So if the employee has an obvious disability and their need for a particular accommodation is obvious, so say an employee presents obviously as blind and they are asking for a screen reader, it would not be appropriate to ask that employee for medical documentation to confirm that they're blind and that they need a screen reader. That would be considered discrimination under the ADA. So you need to be careful. A lot of disabilities, most disabilities are invisible. And so you may need to ask for medical verification of a disability-based limitation and confirmation that the disability necessitates the reasonable accommodation requested if it's not obvious. When you're asking for this medical documentation, you're not looking for diagnosis. You're looking for confirmation from a physician that the employee has a disability-based limitation, what that limitation is, and maybe a statement that that a specific reasonable accommodation would be helpful. You're not required to follow what the doctor recommends as far as an accommodation, but it's helpful to have the doctor confirm the existence of that disability-based limitation. And what do I mean when I say you don't need a diagnosis, you need confirmation of a disability-based limitation? Seems really similar, right? It's different in this way. The disability-based limitation is how the medical condition is affecting the person at work, right? Or in daily life, right? It's how is the person's disability affecting their major life activity. So you could call it a symptom. The diagnosis itself isn't going to help you do your job because it doesn't give you information about what the limitation is that the person's experiencing that's requiring the accommodation. So I really like to use the example of ADHD. ADHD is a diagnosis. And if I get a doctor's note from an employee that says that an employee has ADHD, I don't know as an employer what I need to do to accommodate that person, because ADHD can manifest itself in a lot of different ways. And there's a lot of different functional limitations that might be associated with that diagnosis that are going to vary based on individual and based on the person's job. So it's much more useful for me to have the doctor tell me how the person's ADHD is affecting them, what those functional limitations are. So a functional limitation is going to maybe be difficulty focusing on tasks, difficulty managing time, difficulty staying awake during a meeting. And those are all, those are all going to be associated with a diagnosis, but you don't need to know what the diagnosis is because the diagnosis itself doesn't give you any helpful information here. Another good example of a functional limitation would be a weightlifting restriction. So someone maybe can't lift more than 10 pounds. There could be a whole range of diagnoses that would limit someone's ability to lift more than 10 pounds, but you don't really care what that diagnosis is, and you don't need that medical information because all you need is confirmation from the doctor that the employee can't lift more than 10 pounds. Whether they have a slipped disc or they're pregnant or they have a hip injury doesn't really matter to you. It just matters that they can't lift more than 10 pounds and you're going to have to find a workaround, right? So try to think of it like that. And as I said, you can't request medical documentation if the person's disability and need for particular accommodation is obvious. Now, you've gone through the interactive process. You've gotten your medical documentation if you need it. Now, you've arrived at a decision about how you're going to respond to this request. I think that whether you're approving or denying the request, you should respond in writing. And you should be really precise in describing what accommodation is approved and provide all of the relevant information about the accommodation. So the date equipment is expected to arrive. If you have it, the serial number of the equipment is helpful, so you can keep track of that. The effective date of a schedule change. Sometimes it's helpful to have a review date, especially when you're modifying practices and procedures. Having a review date to see how that change is going can be really helpful both for the employee and for their manager. Include any of that information in your approval letter. If you're denying a reasonable accommodation request, go into detail about why you're denying it. Either, the person doesn't have a disability, why you found that the person doesn't have a disability, or that the request can be denied either for fundamental alteration, undue administrative, or undue financial burden, and how the requested accommodation is a fundamental alteration or is an undue financial or administrative burden. You really need to provide that explanation so that it's clear to the employee and to a court or the MCAD why it's being denied. You're also going to inform staff within the agency who need to know about the accommodation. Like we talked about before, you're only going to provide that information on a need-to-know basis. So only personnel who need to know the information will be given the information, and they'll only be given as much information as they need to perform their duties. When you're denying an accommodation request, you should always let someone know that they have the right to consult with an attorney or advocate, and that they have the right to file a discrimination claim. That should go in your letter. I also really strongly recommend that all public entities have an appeal process in place to resolve disputes over reasonable accommodation denials internally, both for employment and for Title II requests. If you need an example about what this kind of appeal process would look like, we have them in our executive branch handbook, which is linked on the last slide. So you can find that there. So as we're wrapping up Title I, I want to do a couple of scenarios. If you want to try to answer the question, raise your hand and we can ask you to turn your camera and microphone and bring you into the meeting if you're feeling brave. So let's try these scenarios. So the first scenario is Jim, who's a new customer service rep. He has disclosed that he is legally blind and has requested a reasonable accommodation in order to perform the essential functions of his job, including reviewing incoming correspondence, which could be email or handwritten or printed mail. He specifically requested another staff person read documents for him. What are some questions that you would ask during the interactive process? Anyone want to try? Lilia, can you call on people?
Yep, so you can answer by raising your hand, or you can put an answer in the Q&A as well, and I'll read it off. Nope. So someone said, I would suggest not using another employee, but installing software that would read, and if they would be open to that accommodation.
Yeah, that's a really good idea. There's screen reader software that can read digital text to people who are blind. You would need to find another workaround for hard copy mail. You know, printed mail and handwritten correspondence can be trickier because you need to make sure that if you're scanning printed mail, it would need to be OCR'd so that the computer will pick up the words in the text. Handwritten mail can be harder to OCR, so you may need to reassign that to another employee. You might ask if there are magnification devices that could work, depending on his level of sight. Maybe a CCTV would work. So I would work with the person to see, would screen reader work? Is there a way we could reassign some of this work, do some scanning, do some OCR? Good ideas.
Yep, we've got people mentioning screen readers and magnifiers for handwritten material.
All good ideas. All right, so for our next scenario, we've got Mason, who is an administrative assistant for the select board. One of his primary job responsibilities is compiling meeting minutes and distributing them to select board members for review 1 week before the next scheduled meeting. Mason has successfully performed this duty for about 4.5 years, but over the last 6 months, his performance has declined. The town manager calls a meeting with him and gives him feedback that he's been missing deadlines and that recent months' minutes have been inaccurate. During the meeting, Mason tells the town manager that he's experiencing anxiety and depression and asks if he can have additional time to prepare the minutes. How can the town manager respond?
Responses here. You can respond by raising your hand or putting it in the Q&A.
No one wants to get on camera today. I can give you some ideas here. So I really like this example because I think it comes up a lot when employees are facing negative performance evaluations. You're often going to see requests for reasonable accommodations come, and it can be pretty anxiety producing for a manager to navigate that because they don't want to be discriminatory. They want to give the employee what they need, but they also are feeling frustrated because they're having a performance issue, right? And they want to hold the employee accountable. What I want to tell you is that employees with disabilities must meet performance and conduct standards the same way that any other employee would, but they might need reasonable accommodations in order to meet those standards. So you have to provide them the reasonable accommodations they need to meet those standards. But once you've done that, you can hold them to those performance standards. So when Mason brings up his anxiety and depression, he's bringing up diagnoses. So you're going to need to have that conversation, probably get some medical documentation from Mason's provider about what the functional limitations are that are manifesting as part of that anxiety and depression, and how they're affecting him at work, how they're affecting his ability to meet deadlines. Once you've done that, you can have the conversation about what kinds of accommodations might be reasonable. It might not be reasonable to allow him more time to prepare the minutes, since the select board needs time to prepare for the next meeting. But maybe there is note-taking software that you could provide him with. Maybe there are ancillary tasks that Mason does that you could take off his plate. But I think the important thing to remember is you can hold people to conduct and performance standards. You need to understand what the functional limitation of the person is, not what their diagnosis is. And then you can engage in that dialogue about what's reasonable and what might work to accommodate him. All right, so we're going to leave Title I for now.
We did get
unless somebody else wants to say something.
Couple comments in on that one, Julia.
Okay.
You touched on this, but supports or adjustments to the schedule to provide what he needs to deliver on time. And then this was interesting. You could also ask him, are you aware of the benefits you may access for medical services that you might want to?
Yeah, that's a really good point. Yeah. Really good point. All right, so we're going to go into Title II land. Putting employment behind us. Title II of the ADA prohibits discrimination by state and local governments on the basis of disability, and it provides that no qualified individual with a disability by reason of such disability shall be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by such entity. So the bottom line is that you need to make your local government programs, buildings, services accessible to people with disabilities. And that might mean providing a reasonable modification upon request. In Title II land, we're going to talk about reasonable modifications so that we can distinguish them from the reasonable accommodations that we talk about in Title I. It's helpful just as a signal to your own self that you're talking about a different section of the ADA. So I'm going to mix them up and call them reasonable accommodations sometimes in the Title II context. Forgive me, because I'm human. And you might too. You see them used interchangeably, but sort of the correct usage here is reasonable modification. Some tips for Title II compliance. It's really important that you post a non-discrimination statement in all of your municipal facilities and on your municipal website, and that non-discrimination statement includes contact information for the municipal ADA coordinator. This is required by Title II. It is rare that public entities comply with this. And so if you take one thing away from today's training, I hope that you will go back to your municipality and you will make sure that you put prominently on your website a non-discrimination statement that includes the ADA coordinator's contact information. It's required by the ADA. It's also really good practice because a person with a disability who needs a reasonable accommodation needs to know who to contact in order to make that request. So really important. If you need a sample non-discrimination statement, one is available as an appendix in our executive branch disability handbook, which is linked on the last page. We can also send out examples of our non-discrimination statement and the next thing, our grievance procedure after this. The other thing it's really helpful to do is to establish a procedure for responding to requests for reasonable modifications. Very similar to how you would respond to a request for a reasonable accommodation by an employee, but often you're going to have to be a little quicker for a reasonable modification because you don't have that ongoing relationship with the person necessarily. And so, you know, you're going to need to provide an accommodation for an upcoming meeting, and you're going to have to probably act on that pretty quickly. You know, one thing that I, tell people to do, I'm going to talk about this a little bit later, is make sure that when you send out a meeting notice that you're including your ADA coordinator's contact information so people know how to contact them. And then they should have a procedure for how you're going to respond to those requests, a timeline, and maybe you're going to have different kinds of timelines for different kinds of requests. But it's good to have a procedure so that you can measure your compliance. It's also really important that you train your staff on how to keep their facilities and their services accessible. So when people are designing facilities, you should be at the table in those conversations so that people understand from the get-go that they need to make a facility or a project accessible to people with disabilities. And it's good to, think about accessibility early and often. Think about how all aspects of your municipal government need to be accessible to people with disabilities. It's, your buildings, it's your programs, it's your website, everything needs to be accessible for people with disabilities. If you think about it at the beginning during the design phase, it's going to be much easier to make it accessible rather than putting it to the end. So how are you going to make your municipal programs accessible? The first thing you're going to want to do is eliminate unnecessary eligibility criteria. So, ask yourself, is a driver's license really necessary, or is this excluding people with disabilities? Maybe I just need a state ID. Think about how your eligibility criteria might be inadvertently excluding people with disabilities. Provide services in an integrated environment wherever possible. The ADA says you can't have one service for people with disabilities and another service for people without disabilities. You need to provide integrated services whenever possible. You need to provide reasonable modifications to policies, practices to enable access to people with disabilities. So this might be allowing, making sure that your website is accessible to people using screen readers or people using keyboard only. It might be allowing service animals to accompany constituents to your facilities. It might be providing sign language interpreters during meetings or events. It might be providing reasonable modifications to municipal ordinances. You do not need to provide reasonable modifications that would cause an undue financial or administrative burden or constitute a fundamental alteration. We talked about those in the Title I context. They also apply in Title II, but you also, as in Title I, have to engage in that interactive process. And like I said, that interactive process might be a little bit faster and a little bit less in depth for a member of the public than it is for an employee, because you don't have that same ongoing relationship. But you still need to engage in a meaningful dialogue with the person about what they need and how to best serve them. How are you going to make your facilities accessible? You need to make sure that any facilities that you are renovating or constructing comply with the 2010 ADA accessibility standards or local access board regulations. So that would be the MAAB regulations here in Massachusetts. Use whichever standard provides greater access. If parking is available at your facility, make sure that there are accessible spots and that those spots have clear, unimpeded access to an accessible entrance. Make sure that hallways and doorways are unobstructed by boxes, furniture, or other obstacles. You're gonna, build a perfectly accessible facility and then ruin the accessibility by stacking a bunch of bankers boxes in the hallway, making that hallway too narrow, right? So make sure that you're including storage of things like boxes in your design to make sure that the facilities remain accessible. Make sure that signage at your facilities is clear and displayed in high contrast raised letters and braille. Allow sufficient room for wheelchairs to navigate meeting rooms, break rooms, and other seating areas. And then, more holistically, consider how people are going to use the space and what barriers people with disabilities may encounter, either when you're, renovating a facility or just when you're going through a meeting room to set up for a meeting. Think about how people with disabilities are going to travel through that space and use that space and what barriers they might run into. Do you need to move a table? Do you need to adjust the seating arrangement? Now, how are you going to make your meetings and events accessible? Towns have so many meetings that they run, right? Cities and towns have a lot of meetings, they have a lot of events, and we have to make them accessible for people with disabilities. So what are we going to do? For all meetings, make sure that you are providing instructions for how to request an accommodation. It's a good idea to do that on your meeting notice. So if you're posting a public meeting notice, put in your public notice how to ask for reasonable accommodation modification, so that it's really clear to everyone who might be interested in the meeting how they would make that request. It's a good idea to be proactive about signing up for communication access, such as an ASL interpreter or CART reporter, ahead of time to make sure that they'll be available on your meeting date. You can do that through MCDHH, the Commission for the Deaf and Hard of Hearing. They have an interpreter referral service that you can use as a municipality. Make sure that for all meetings, you are verbally describing any visually presented information, For in-person meetings, make sure that the venue where you're holding your meeting is accessible. And I know that this becomes a problem for large events. When municipalities hold large events, either public meetings that are going to draw a lot of attention, or town meeting is a big one, it can be really hard to find an accessible venue. Find one. And I care less that you have to go one town over to get an accessible venue. You need to find a venue that's accessible for people with disabilities, period. You need to be holding your meetings in places that are accessible to people with disabilities. Make sure that within the meeting room, there is sufficient room for someone who uses a wheelchair. So leave a couple spots, without a chair so that someone with a wheelchair can pull into them. If you're providing communication access like ASL or CART reporter, make sure that there's a clear line of sight. Sometimes it can be helpful to reserve some seats with a clear line of sight. So if you know that there are people who are going to be using those services. For remote meetings, if you have an ASL interpreter, make sure that they are spotlit. So you'll see our two interpreters here today are spotlit on the screen so that they're, appearing at all times and they're a little bigger. That's going to make sure that all of your attendees have access to that interpreter. Make sure that you're providing a CART link to folks who need it if you have a CART reporter. Have a plan for how you're going to call on people who can't use the hand raise feature. Maybe they can type into the chat or otherwise signal physically that they need they need assistance, to be heard. My personal passion is digital accessibility. So I get very excited about this part. It's really important that your town website or your city website is accessible to people with disabilities. The DOJ this year has clarified that both Title II and Title III of the ADA require websites to be accessible. So they have started looking at this. They have started, we've seen in the last month a DOJ settlement with a public entity over an inaccessible website. This is something that the DOJ is going to be doing more investigations of, more enforcement of in the coming months and years. Make sure that when you buy an IT product, be it a website or some kind of web-based service that you make available either to your employees or to the public, that those IT products are accessible to people with disabilities. And make sure that they're accessible before you buy them, because it's a lot harder to mitigate something, after you bought it than to make sure that it's accessible from the get-go. This might mean hiring an accessibility audit vendor. You can do that off of a statewide contract. The statewide contract is called ITS 61, and it is a contract that will let you hire either an accessibility consulting vendor or an accessibility audit vendor who will take a look at your website or a software product and tell you if it's accessible. They can tell you that before or after you buy it, but it's a really good idea to buy those services so that you make sure that you're in compliance and that your product is actually accessible. Make sure that the documents that you're providing to your employees and to members of the public are accessible. This isn't necessarily going to be expensive. You can use a built-in accessibility checker in word processing or presentation software. You can use headings in electronic documents like Word documents or tags in PDFs to help people who use screen readers navigate the document. Make sure that if you're using a PDF document, you're using the character recognition so that text is readable by screen readers. If you scan a document and don't take the additional step to OCR it, it will come across as a flat image with no text to a screen reader. If you're including images in documents, make sure to add alternative text. MOD did a training on sort of how to make documents accessible, digital accessibility, a couple of weeks ago. And there's a video of that training available on our website. I want to take some time to talk about our municipal ADA improvement grant program. We just announced the recipients of our 2022 grants or FY23 grants this week. This is a grant program that supports capital improvements to municipal facilities aimed at improving programmatic access or removing barriers encountered by people with disabilities. So there's two different kinds of grants. There's the planning grant that will fund a municipality's self-evaluation or transition plan. And then once you've done that, you can apply for a project grant that will fund the removal of architectural or communication barriers in municipal facilities. So this, towns have gotten really creative with grants they've applied for. We've had a couple towns install beach access maps and boardwalks to allow people with mobility disabilities to access town beaches. We've had towns install assisted listening devices in town meeting rooms to improve communication access. We've had towns install accessible pedestrian crossings. So, towns are pretty creative about what they're, and when I say towns, I mean cities too, sorry to the cities out there. Our municipalities have been really creative about the kinds of projects that they've sought funding for. We will be opening our FY24 grant this summer, probably around July. So keep your eyes peeled for that grant announcement, which should come in July of next year. And if you got an award this year, congratulations. All right, so we've got a couple scenarios for Title II. And this first one is a little bit of a trick question, so we'll see if you guys catch the trick that I put in here. Susan Miller recently purchased a home in a municipality. She uses a wheelchair. She requests a zoning variance to allow her to build a ramp into her home that would extend 5 feet into the front setback. Susan's application does not meet any of the requirements for variances in the municipality's zoning ordinance. How should the ZBA handle this request? Any thoughts? You can either raise your hand or type it into the Q&A.
We've got a raised hand. I'm going to turn your microphone on. Okay, are you there?
Hello, I'll break the ice. My best take it on this would be that the federal requirement to allow citizens to live in a town in an accessible way would trump the local zoning board rule, and that they would approve a variance for that ramp for Susan.
Great answer. Yes, generally in most states, that's the perfect right answer. It's a trick question because Massachusetts zoning law actually allows variances for setbacks by right for the construction of ramps to access buildings. So there's a little bit of a trick question, but that's the right answer. That yes, the requirement to provide reasonable accommodations would trump the zoning variance, and they would have to grant it. So thank you so much.
Oh, thank you. Yeah, that was fun.
Good, yay. That's why I do this. All right, so Title II, Scenario 2. Norman is a newly appointed member of the Historical Commission, which meets monthly on the second floor of Town Hall. Norman uses a wheelchair. Town Hall's elevator has been broken for several years, and the second floor is currently inaccessible to Norman. What are some solutions to make the Historical Commission meetings accessible? You can raise your hand or put it in the chat.
We've got Kay again with an answer. There, great.
Oh, hello. Thank you. What I would suggest is that the Historical Commission immediately relocate their meetings to an accessible meeting room in town, and that the town manager or facilities director request some free cash to get that repair done immediately.
Perfect. Perfect answer. 10 points.
I've been attending a lot of meetings lately around the town.
Good, good. That's exactly right. They should have the meeting in an accessible location, and they should fix that elevator as soon as they can. If they don't have the funds to fix the elevator, they can ask MOD for those funds through the municipal ADA grant program if they've done a transition. So something to keep in mind if you are short on cash.
We've got some enthusiastic messages in the chat or in the Q&A. Move the meeting to the first floor, fix the elevator, and use a different meeting room in the meantime.
Perfect. Good questions. Everyone gets 10 points. Absolutely. So let me take us to our third scenario. The library in our town is making a new website, and the head librarian asks you, the ADA coordinator, what they should consider when building the website to make sure that it's accessible to people with disabilities, and how should they go about it? What are you going to say to them? Do we have anything, Lilia? It's a hard one.
I don't see anything. Well, people are thinking that through. I also want to say I've been putting some links and resources in the chat, so make sure you check that out. We'll also send those in an email and a recording and the slides to everyone who registered. Kay's got her hand raised, or Jeffrey's got his hand raised, so I'm gonna call on you. Switch it up. Jeffrey, are you there?
Hello, isn't everyone hearing me all right?
Yes.
Okay.
Thank you, Jeffrey.
Yeah, hi everyone. So I've been to a few libraries throughout Rhode Island as part of my job when I'm getting called to go out for new construction, or if I get technical assistance kind of calls. I've gotten a few from libraries, and a lot of it was making sure that a certain portion of like meeting rooms and sorts of things like that are accessible and available to people with disabilities. Because in this specific case, they needed to put, or they wanted to put more your kind of like small meeting rooms up on a second floor that would not be accessible. So in this specific case, we had to make sure that a certain percentage of those types of rooms were available to people with disabilities.
Yeah, exactly. In this scenario, we're talking about their website, though. So,
yeah, that and
sans
serif. I know that a lot of those, like that type of print, is easier for people with vision issues. You know, making it specific colors that are going to stand out to people. A lot of that are, I'm sure, Massachusetts, and I know Rhode Island, we've gone through updating our website and changing it for accessibility throughout the last 6 months to a year.
Yeah, very good. So my recommendation would be to familiarize their, it looks like we have a comment in the Q&A too. Lilia, can you read that?
Yep, somebody says hire a qualified web builder and require ADA compliance. All photos uploaded need to have a description with no abbreviations or acronyms.
Yes, very good. Those are some really good ideas. Anything else, Lilia?
Yep, we got one more comment. For websites, I would refer them to the IT administrator for some guidance, and I would find some referrals to the many free trainings in WCAG that are available.
Yes, yay, Kay, thank you for bringing up WCAG. So I think really good ideas here. Hire a qualified web builder who's familiar with accessibility standards. A really good set of accessibility standards to use are the WCAG standards, which you can find on online by Googling WCAG standards. They're put out.
Missed the standard. What was the acronym?
WCAG. So the WCAG WCAG standards are sort of the gold standards around web accessibility. make sure that they're aware of them. That's going to include things like using sans serif text, using high contrast for visual things, using image descriptions. So, so those are some like good places to start. You can also hire an accessibility audit vendor, an accessibility consulting vendor off of statewide contract ITS 61. And that will give you some help too. All right, we've got one more, but I see that we have a lot of really good questions. So I'm gonna skip this last scenario and go to our resources. And then I wanna get into the questions because I see some really good ones in here. So this is our resource page. We have a couple resources for Title I. We have the Job Accommodation Network, which I think I referred to earlier. Excellent resource for employment ideas. They have really good trainings as well. You can call them or email them questions about a specific accommodation request that you get, and they will offer feedback and ideas. Really helpful. The EEOC also has this really great resource for employers on applying performance and conduct standards to employees with disabilities. You know, we did that scenario where we had that intersection between an accommodation request and performance feedback. This can be really helpful when you're navigating that scenario. And I like to give this to all my managers and supervisors to make sure that they know how to navigate those situations if they come up, and they know when to loop me in as the ADA coordinator. On the Title II side, ADA.gov is excellent. They just had a website refresh that is beautiful and much more easy to navigate and find information. I really like the Department of Justice's primer for state and local governments. I go to it all the time. We also have the ADA checklist for existing facilities, really helpful checklist. You can go through and see if your facility meets accessibility standards. We also have this Title II action guide that is really helpful, practical, kind of step-by-step guidance. We have accessible parking guidance for you. We have the DOJ's guidance on web accessibility that came out earlier this year. We have MOD's guidance for hosting accessible virtual meetings. We also have MOD guidance for outdoor events or accessible outdoor dining, if that's still happening in your town or city. So definitely check out these resources. You can also contact MOD as a resource, either email us, call us. We are here to help you guys and we want to be your partners. So let's get to the questions, please, Lilia.
Great, we've got several great questions here. So our first question is, are there minimum requirements for someone to fill the role of ADA coordinator? Something like a minimum knowledge or a certification? If an ADA coordinator is poorly informed or acts counter to the intent of the role, is there recourse for rectifying that?
Really good question. So there isn't official requirement from the DOJ that an ADA coordinator hold a certain certification or certain education requirements. The ADA coordinator should be knowledgeable of the ADA and have the analytical skills to be able to sort of advise the municipality on their obligations under the ADA and engage in the meaningful, in a meaningful interactive process with employees and members of the public. There's one certification, sort of formal certification program for ADA coordinators that's put on by the Great Plains ADA Center. It's not required to be certified in order to be an ADA coordinator, but it's a great idea. It's a great training program. If an ADA coordinator is not sort of fulfilling their responsibilities, I think, it's a great thing to bring to the attention of your chief executive officer within your municipality. So your select board, your mayor, city council, someone that, you know, this is a real liability for the town if the ADA coordinator isn't fulfilling their obligations. And so it's something that they should take really seriously because you are exposing the town to potential liability under the ADA. Next question, Lilia.
Thanks. Next question is, how do we post the non-discrimination information prominently for all the many virtual meetings and programs, especially if our community members have dropped out of things because things have not been accessible to them?
So I think you should put your non-discrimination statement on your website in a really prominent place. And then you should put on meeting invites, put your little statement. It can be short. It can be, you know, this, you know, the municipality is committed to non-discrimination, to request an accommodation, contact the ADA coordinator and provide their email address and phone number. Really short and sweet. Make sure that it's on the website and going out in sort of, you know, if you have a town, some towns have newsletters, some towns, you know, if you want to post a notice in the newspaper, you could do that, the local newspaper. But you should always have that non-discrimination statement on your invitations so that people know how to, you know, or invitations and meeting notices so that people know how to request that.
Thank you. Next question, is there funding available for a website accessibility audit?
Yes, you can ask us for funding for a web accessibility audit. If you're using capital funding to fund the project, you can do that through the municipal ADA grant program. And I would love to see an application for FY24 for that kind of project.
Thank you. Does the onboard live transcript feature provided by many meeting applications rise to the level of acceptable closed captioning?
It depends. You know, accessibility is going to mean different things to different people. The sort of default live audio transcription on programs like Zoom, Teams, WebEx, Google Meets is getting better. Whether it's going to meet someone's needs, it needs to be determined on a case-by-case basis. So I don't think that you can safely say yes to that because depending on someone's disability, that may not be sufficient for them. Because, you know, any reasonable accommodation request has to be considered on a case-by-case basis. There isn't really, unfortunately, a lot of bright line rules around accessibility. So I would still, you know, if someone's asking for real-time transcription that you get from a human being, that you get from a CART reporter, I'd you know, ask them, you know, if you're resistant to that, I'd ask them, you know, why they need that and try to understand, you know, how that service would be different from what they would get from the auto transcription that is available on like Zoom and Teams. So the answer is maybe.
Our next question is, why wouldn't the building department be the ADA coordinator?
It could be. Some building inspectors are ADA coordinators. You know, you need to have an ADA coordinator that is familiar with the requirements of the ADA and has the authority to make decisions on, you know, reasonable accommodation requests. So it could be a building department. We do see that in a lot of municipalities. But you need to make sure that the person knows how to do the job and has the authority to make decisions.
Our next question is, why aren't local post offices required to have automatic door openers? I can get into the town hall, but I can't open the double doors of the post offices or the banks from my wheelchair.
probably depends on when the post office was last renovated. So if the post office hasn't recently been renovated, the new ADA standards might not apply to them. So if you have a concern about a post office and it's in Massachusetts, you could file a complaint with the Massachusetts Architectural Access Board. But if the post office hasn't been recently renovated, they're probably not going to be required to meet the standards. So that might be why. Same with a bank. But if you do have a concern, if you know that it's been renovated recently, then you can file a complaint with the AAB or the Architectural Access Board, the US Access Board level, or the Massachusetts Architectural Access Board.
And I just shared our contact information in the chat as well, if you want to discuss that more in depth, or if anybody has questions we weren't able to get to. Can do one more. Our next question is, must a municipality's ADA coordinator be an employee of the town or city? Do some municipalities in Massachusetts use a contracted person or a volunteer?
The best practice would be to have the person be an employee. I think you could possibly do a contracted person. I would not have a volunteer. I think that is risky. But the best practice would be to have it be an employee.
Okay, and we've got one more question. We applied for a planning grant. However, I do not believe we received follow-up. Who would that have come from?
It should have come on Monday from Evan George. So if you haven't gotten follow-up, reach out to Evan George. And if you want to give us what town you're from, we can follow up with him as well.
All right, I think that's all our questions. We'll have a survey that'll pop up as soon as you log out, so make sure you fill that out. And I'm putting Evan's information in the chat too for whoever asked that question.
Great. Well, thank you so much, everyone, for attending, and best of luck in your ADA coordinator endeavors. We are always here to answer your questions.
Thanks, everybody.